Good afternoon, dear professors and dear guests. It is a great honor for us to host you in the 5th seminar of Comparative Law Seminar Series today. Welcome all, and thank you for being with us today. We have very distinguished guests, professors, colleagues, and students today. So today we will listen the presentation of Professor Alfredo Moliterni on judicial review of complex technical assessments, the Italian experience in a comparative perspective. And today's seminar is especially important for me, actually, because dear colleague, Professor Moliterni, is an old friend of mine. We met during the Academy of European Public Law of EPLO, and it is a great pleasure to host him today. And thank you very much. I would like to thank him very much for accepting our invitation. And as you know, Comparative Law Seminar Series are co-organized by Kadir Has University Faculty of Law and Kadir Has University Liability Law Research and Practice Center. So firstly, I would like to give the floor to Associate Professor Nilay Arat, the director of the center. Please, Professor.
Thank you very much, Aslı. It's my great honor and pleasure to welcome all of my distinguished colleagues, our students and guests, to another one of the Comparative Law Seminar Series, as referred, jointly held by KHAS Law School and the Liability Law Research and Practice Center. If you allow me, I would like to offer a few words on our distinguished guest today. We are hosting Professor Alfredo Moliterni. I would like to extend my warmest welcome to our guest and our distinguished colleague and my dear friend. Alfredo Moliterni is a researcher in administrative law and professor in administrative law at the Department of Legal Sciences of the Faculty of Law of Sapienza University of Rome. Also, he teaches there administrative environmental law and territorial governance and comparative and European administrative law. He teaches numerous universities at master's level and grad schools and at the National School of Administration. He also taught in Kadir Has University Law School as well a few years back. He worked as a legal advisor to the Minister for Cultural Heritage and Activities and a member of the FOIA Competence Center at the Department of Public Administration of the Presidency of the Council of Ministers. He has conducted studies and research at the Columbia Law School of New York and the Max Planck Institute for Comparative Public Law and International Law in Heidelberg. He's a member of the International Society of Public Law and a member of the European Scientific Council of the European Public Law Organization in Athens, where he also obtained his International Intensive Master of Laws in European Public Law, and also where we came to know each other as well. Professor Moliterni is going to speak mainly about the judicial review of administration, and in specific, he will elaborate judicial review of complex technical assessment in a comparative perspective. It's my honor today to introduce and host my dear friend and my distinguished colleague as well. So, dear friend, dear colleague, Alfredo, with a hope today inspires ideas and give a way for fruitful discussions. I leave the floor for your valuable contributions. And again, thank you for accepting our invitation and honoring us here today. Please, the floor is yours.
Thank you very much, Professor Arat. Thank you very much, Ashley, for this presentation. I'm very honored to have been invited to give a lecture at this prestigious university in the context of comparative law seminar. I already had the pleasure to appreciate the scientific quality of Kadir Has University research and teaching activity in 2015 when I gave a lecture in the course held by Professor Nilay Arat. Unfortunately, today we may only see virtually, and I very hope to be able to come to Istanbul soon after the pandemic emergency. I particularly thank Dr. Ashley Topuku for her kindness in the organization of this seminar, but also for his friendship for many years ago in the context of the scientific activities of European Public Law Organization, where I met also Professor Nilay Arat. So many thanks again. As Professor Nilay said, we're going to talk about judicial review of complex technical assessment of administrative activity. We are going to deal with the Italian experience within a broader comparative perspective. Here you find a very short summary of the lecture. First of all, we are going to analyze some methodological remarks for the comparison of judicial review system. Then we are going to enter more in detail in judicial review on complex technical assessment, analyzing some trends in a comparative perspective. Then we will analyze the Italian experience of judicial review, and we will stress also some critical remarks on Italian case law. And finally, we will stress some conclusion on judicial review in order to find a better balance between administration and courts. So first point, comparing judicial review. As you know, in several countries, the very foundation of administrative law can be traced back to the theorization and establishment of a specific system of judicial remedy against public power. Every country has faced the problem to rationalize the relationship between courts and administration. And in this perspective, several theoretical categories such as administrative act, administrative discretion has been used, mainly served to regulate the space for and limits to the court's intervention. For this very reason, judicial review of administrative action is a privileged ground for administrative law comparison, for comparing administrative law system, and the increasing comparative attention on judicial review system has encouraged a strong circulation of issues and a strong circulation of problem about judicial review, also beyond the structural divergences of administrative law system, also beyond the distinction between civil law countries and common law countries. We stress a progressive convergence of different model of judicial control of administrative action all over the world. For example, as to the objective of judicial review, all the system has tried to challenge to better harmonize the two traditional dimensions of judicial review: the objective dimension, the need to ensure legality of administrative action, and the subjective dimension, the right protection. For example, in UK from the 90s, the traditional perspective of judicial review, that was an important tool to give effect the rule of law, has commenced to deal with the objective to strengthen the protection of fundamental rights in the so-called multi-stream jurisdiction. So the convergence of objectives and has encouraged also a strong circulation of different techniques and methodologies of judicial control of administrative action. The examples are several and well known: the reasonable standard, principle of proportionality. As to the reasonableness standard, it has been established in UK in 1948, but this standard was received also beyond the common law and the Commonwealth countries, for example, in the Italian, Belgian, Dutch courts, while in German and in France is not a self-standing yardstick of judicial review. The proportionality principle was developed in Germany, but in the last decade, also through the European jurisprudence, has become a general ground to control public powers in several member states, such as Italy, France, and also in UK. While in the 90s, the courts were reluctant to apply a proportionality test as a ground of review. And now this test is applied also beyond European and European Convention of Human Rights Matters. It has become a common law head of review. But in spite of these convergences of techniques and objectives, many differences remain in the concrete application and implementation of review standards. Same labels of judicial control often hide structural divergences in the way the courts use them to supervise administrative activities, for example, under the broad categories of unreasonableness is possible to find a multiple standard of review that go from a light touch to an anxious scrutiny, from a soft look to a substantive control, and also the variable extension of unreasonableness test has accentuated the difficulty to clearly distinguish it from the proportionality test. As to the proportionality test, there is a wide discretion, of course, in deciding how intensively proportionality should be applied. There are theories about 4 stages of proportionality, 3 stages of proportionality, but beyond that, especially at European level, has been stressed, for example, by Professor Tridimas, that this standard is used in different contexts to protect different interests and entails varying degrees of judicial scrutiny. Also, there is an unclear distinction between rationality test and duty to give reason, and in this perspective, the obligation to give reason swings from a procedural and formalistic conception to a substantial one. How this is important? Because all these tendencies and dynamics suggest some preliminary remarks that are important from a methodological perspective. The first point is to avoid to rely excessively on rigid and universal standard categorization of judicial review, since all of them are inherently flexible and open to more or less a differential application. The second point is the need to be very cautious in comparing abstract models of and techniques of judicial review. Judicial control cannot be reduced to a scientific or engineering formula that could be transplanted from a legal order to another one. Judicial review is strongly connected to the constitutional dimension of each legal order. And in particular, is very important, as stressed by Professor Kane in a very important book of 2016, Controlling Administration. It's very important the specific level of concentration of political and executive powers within each legal order in order to shape the intensity of judicial review. So these preliminary remarks are very important to set the problem of intensity of judicial review on complex assessment in a comparative perspective. As to the specific point of judicial review, having regard to all these elements, judicial review on complex technical assessment is a very interesting perspective to understand the main dynamics that are characterizing administrative law system at global level, as well as assess risks and opportunities of legal comparison in administrative law fields. Why this? The reason depends on the extension of technical and scientific power within our legal system, which represent one of the most important features of legal system in the last 30 years. It is closely linked to the need to regulate and govern increasingly complex and interconnected social phenomena, environmental, food security, financial markets, artificial intelligence. So rapid and scientific change need to be validated continuously and very quickly by public authorities, and this contributes to widening the areas of intervention of administration, as it has been stressed by Seinstein and Professor Seinstein and Vermeulen in their recent book on Law and Leviathan on 2015. There is a strict connection between the establishment of administrative state and the need to provide an authoritative and expert answer, also from a technological and scientific perspective, to the social question and to the growing regulatory need. Of course, the technicalization of administrative powers is related also to the supranational international dimension. technical and scientific rules are very important tools to standardize national powers and coordinate national responses at global level, as stressed by Professor Sabino Cassese. In this context, two approaches emerge in the concrete relationship between administration and judge before technical complex assessment. First one is a differential approach, and the second one is an intense scrutiny approach. Let's go to the first approach. The first approach tends to preserve and recognize a wide space of autonomy for administrative agencies, enhancing the technical impossibility of the judge to replicate their complex assessment. To these purposes, it's very important the distinction between question of fact and question of law. While with respect to question of law, there is frequently an explicit refusal to recognize area of deference by the courts. For question of facts, courts are sometimes less inclined to interfere with administrative assessment, since it is stressed that administration have more fact-finding skills, are much more able to evaluate and to assess complex facts. So this distinction is very important, as we will see in the comparison of US system and European system approach on complex technical assessment. This differential approach has been mainly consolidated in the US legal system, but not all in US legal system. Indeed, after an attempt to recognize a very strict judicial review in the 60s and in the 70s on the basis of the standards of judicial review that were provided in 1946 by the APA, paragraph 706, such as unreasonableness, abuse of discretion, lack of proper preliminary investigation, insufficiency and inconsistency in the statement of reason. Starting from the 80s with a clear overruling, the Supreme Court established criteria and limits to judicial review on independent agency assessment. It is the so-called deference doctrine that is related to a landmark case in the United States, Chevron case of 1984. In this case has been established that, as probably you know, that when legislator delegates an agencies to regulate some issues, or there is an undetermined legal concept, this is a second possibility, the judge cannot substitute its own interpretation of law with the reasonable interpretation made directly by the agency. So if the agencies declares that the legal interpretation provided by the law is vague and therefore has given its own interpretation, then the judge must limit itself to assessing only the reasonableness of this interpretation. Chevron was based on two steps or two conditions to defer. The first point, Congress has not spoken directly to the precise issues at question. The agency's answer is based on a permissible construction of the status. As you may underline, deference doctrine in this legal context is linked both to the technical and regulatory skills of administration to be safeguards, but also to the peculiar institutional position of agencies at constitutional level. US administrative agencies are entitled to give the proper interpretation of the law, since they are entitled not only to execute the law, but mainly to regulate it. And this differs greatly the UX experience from the European one, where courts are the main actor of the interpretation of status, and administration are mainly entrusted only to execute the law. In this perspective, US deference is mainly a consequence of the broad regulatory power conferred to the agencies by the Congress. This is a Chevron space, as has been called by Professor Strauss of Columbia University. It is the logical result of the democratic choice to entrust in agencies, and not a judge, the role of defining and interpreting some rules within that jurisdiction. Of course, beyond the clarity of the theoretical assumption, Chevron remains one of the most controversial cases in American law, has given rise to many oscillations between a strong deference or more intensive scrutiny, especially if we compare the courts of appeal approach and Supreme Court approach. There is different approach, as stressed by a recent research of Ken Barnett and Christopher Walker, but there is also very different in application of Chevron that depends also in the peculiar nature of the matter involved. For example, there is strong deference in technical and economic matter. There are a lot of studies on this point. One of these has been carried out by Eskridge and Beer on this different application of Chevron standard in different fields. But beyond US, a prevalent tendencies to defer in complex technical matters emerge worldwide. It is a de facto deference, as John Wright has stressed. He referred to de jure deference, the typical US deference, and de facto deference is a deference that emerged all over the world, which refers to a general course attitude to consider the weight of opinions and assessment carried out by a public administration with regard to the way in which they are adopted, but also to the specific constitutional values that they express. This is a substantial underpinning of deference that is frequently recognized in fields and areas characterized by the exercise of technical or scientific assessment, has been clearly demonstrated by a recent research of Zhu, deference to administration in judicial review, comparative perspective, Cham, Springer International of 2019, where it is stressed that the presence of an assessment that requires high level of technical expertise frequently justify less intrusive judicial control in several jurisdictions, Australia, New Zealand, Japan, also beyond the structure of the legal system in consideration. Only in few cases, only rarely, this differential approach is expressly determined by the law. There is one case, is the Chet's legal order, where judicial review is excluded expressly by the law for administrative decision which depends solely on the state of health of person or is of pure technical nature disputes, unless it represents by itself an obstacle to the pursuit of profession, employment, business, or other economic activity. The very problematic issues is that the concrete extension of this technical space varies considerably from system to system. It's not difficult, it's not easy to say when we are before a technical field, when we are before a pure technical litigation. There are different criteria that have been adopted. And for example, in several countries, the same environmental disputes sometimes are considered to be characterized by technical assessment, and they are subject to a great deference. Other times, they are considered as part of, are considered relevant for the public interest that there is behind the environmental field, and so this aspect justify a strict review. So a very crucial point is the difficulty in defining what is technical matter, also beyond the problem of intensity of review. A second judicial approach tends, on the contrary, to recognize a stronger judicial intervention on complex technical assessment and complex technical evaluation. What is the theoretical presupposition of this scrutiny approach? The presupposition is that it's possible to find a contraposition between technical scientific assessment and pure discretion. So technical scientific assessment are considered in contrast to pure discretion, being not related to political choice. And these tendencies emerge moreover in European Union context, where the presence of technical discretion in European Union is not expressly used, this term that is used in Italy, as we will see, but the concept is this: there is a contraposition between the assessment provided on the basis of political choices and assessment provided on the basis of technical elements and technical rules. And this contraposition has allowed for a strict review for technical discretion and technical assessment. And it happened especially in the antitrust and economic regulation disputes, where there has been an intensification of review on fact-finding and reasoning process. This is a very important point. Of course, in the European legal system, the opposition between technical assessment and discretional assessment has been encouraged also by the Meroni doctrine, which allowing Commission to delegate to agencies only technical assessment tasks. This theory has strengthened the theoretical contraposition between discretion and technical assessment. And in this perspective, it's possible to underline an intensification of European Court of Justice control on complex technical assessment that was based on duty of care, the obligation to state reason, and principle of proportionality. In this context, also the traditional boundaries between procedural review and substantive review of scientific soundness of the assessment have become less rigid. And in that case of Bilbao Alquintranes, through a procedural control, the Commission has been obliged by the court to adopt a different methodological, scientific methodological for his assessment by the court. So the distinction between procedural and substantive review became less rigid in this context. And also, the traditional manifest error that remain, that is continue to be used by the court, has evolved from a very light review toward a deeper review, entailing also a direct examination of factual basis for the decision. It is related to the Pfizer case of 2002, and according to the most important scholar, the most important case was Tetra Laval of 2005 of these tendencies. And the marginal standard of review has encouraged to a change in the standard and scope of review with an intensification of judicial control. And it happened especially in risk regulation and competition disputes. In a very recent case, Bayer Crop Science versus Commission, the court ruled that in the exercise and in controlling the assessment of the court, the European Court of Justice must verify whether the relevant procedural rule have been complied with, whether the facts admitted by the Commission have been accurately stated, and whether there's been a manifest error of assessment. There is an important obligation to examine carefully and impartially all the relevant elements of the individual case and to give an adequate statement of the reason for its decision. The courts must carry out an examination of plausibility of the Commission assessment, given the impossibility of having full scientific certainty, but without substitute its own assessment of course, remain some uncertainties also within these jurisprudential trends. There is sometimes an unclear distinction between material facts and relevant consideration. There is an unclear extension of the Commission margin of appreciation. There is a softer review on EU agencies' assessment. The stricter review usually is for the decision that involve acts and decision of the Commission and not decision provided by the agencies. Why? So we come back to the necessity to put the consideration about judicial review in a wider institutional and constitutional context. Why? What are the most important reasons for a stricter review? First of all, the intensification of judicial review is important for an intensification of the process of European integration. Courts, second point, courts are the natural and sole guardian of the correct interpretation of European law. It is provided by Article 19 of the European treaties, and these exclude those space of deference that are, for example, recognized in the US system to the agencies in the interpretation of the statutes. The third point is that the intensification of judicial review is a sort of legal counterweight to the democratic deficit which characterized the European legal order, and it contributes to render more accountable EU law and strengthen agencies' legitimacy, as stressed by Paul Craig. Fourth point, effective judicial protection principle is a projection of economic freedom and liberties recognized by the treaty to private entities vis-a-vis public authorities. And for this very reason, a stricter review emerged in the field of economic regulation, antitrust, and public contracts. Also in the European Convention of Human Rights system, it's possible to find a connection between the intensity of judicial review and technical and the protection of fundamental rights and economic liberty, especially through an application, a strong application of Article 6 of the Chart of the Chart of the European Convention. In intensive judicial review on the substance of the administrative decision, it's important in order to protect economic freedom and property rights, especially vis-a-vis the exercise of very restrictive measures. Most important decision occurred in antitrust law sanction, but also in sanction related to financial supervision law. And of course, in this context, in the light of this supranational influence, several European countries have ensured intensification on judicial review, on technical assessment, not only in systems such as Germany, where they were characterized by a long-standing focus on the protection of individual rights even before undetermined legal concept, but also in other systems such as France and Italy. And now we're going to analyze the Italian experience on judicial review on complex technical assessment. It was a situation characterized by traditionally a very weak control by administrative courts on complex technical assessment in the last century. The theoretical category of technical discretion has been developed by the legal science and jurisprudence precisely to preserve a wide area of autonomy to administration and to justify differential control. Administrative courts were entitled to verify only serious biases and manifest error in the assessment, as well as the fairness of the procedure. It happened in cultural heritage assessment, public examination, public competition, environmental protection, medical assessment. Behind this self-restraint, there were some legal and factual elements, also institutional elements. First of all, it was stressed by the legal scholar the wide margin of uncertainty in the technical rules to be applied for the qualification of the fact, and that cannot lead to an unequivocal outcome. Second point, technical assessment has been considered a typical administrative task, and so this self-restraint was related to the need to safeguard the separation of power. Deference as the result of the constitutional relevance of some interest to be protected by the administration in the interest of the whole community and not through individual applicants. It is clear for the landscape, environmental and cultural heritage protection that is provided by the Italian Constitution. The last point, it was that there were pure and weak tools of preliminary investigation and fact-finding tools in the previous discipline that regulated administrative trial in the Italian system. In the late 90s, a strong first intensification characterized the dispute concerning medical assessment, service-related disease, and according to the Council of State, it was a very important decision for the Italian administrative law system, 1999-601. Technical discretion can be reviewed through the direct verification of the reliability of non-technical operation in terms of their correctness, having regard to the technical criteria and application process. In this situation, was very important also some relevant change in the administrative trial legal discipline. Judges have been allowed in 2000 by the legislator to seek expert technical advices, and it's very important the strengthening of judge power on fact-finding, because it's very important to ensure an intensification of judicial review, as the US experience confirm. In US, there is an important limitation of judicial power on fact-finding, and it is one of the main reasons of deference in many jurisdictions. A stronger shift in the intensity of judicial review has mainly characterized in the Italian system the litigation on independent authorities. Why this? This is related to several institutional reasons. First of all, independent authorities are characterized by, it was a model that emerged in the 90s, mainly in the 90s in the Italian legal system. Independent authorities are characterized by the exercise of technical assessment instead of pure discretionary power, unlike ministry. In their assessment, the public interests are defined by the legislator, which require only technical implementation by the agencies, the so-called conditional regulation. Before independent authorities, judicial review is also a tool that is important to strengthen the democratic legitimacies of independent authorities through an ex post control. In this context, the Council of State in the last 15 years started explicitly to declare its intention to exercise a review tending to a European common model in accordance with the principle of effective judicial protection, especially in antitrust and economic regulation litigation. And why? Because they are fields that are characterized by a clear foundation in European Union law. In antitrust litigation has been affirmed a strong and intrinsic review of technical discretion using the same technical knowledge of the specialistic science for the assessment on restrictive practices, abuse of dominant position, merger. Administrative courts in this context may, first of all, interpret the undetermined parameters such as relevant market, predatory price, cartel, abuse. Secondly, they may replace the assessment of relevant facts for the decision. Third point, they may verify the contextualization process, so the evaluation of relevant facts under the legal parameters. And they may verify if the technical scientific assessment are placed outside any sphere of accuracy and reliability. Finally, there is a verification about the proportionality of administrative sanction in relation to the assessment of facts. In very recent antitrust case law, Avastin Lucentis of 2019, the Italian Council of State ruled that in making this assessment on complex technical evaluation, the judge must not only check whether the assessment fall within the reliable ones, but whether it is the most reliable. So this kind of review has been defined of a greater technical reliability, even if also in this judgment is specified that judge cannot extend his assessment to the opportunity or convenience of the administrative decision, it's very clear that this latter approach seems to be very close to the complete replacement of the antitrust authority decision. A very strong judicial intervention characterized also the economic regulation disputes. In this field, there have been a tendency to enhance the space provided by procedural or formal error, especially inadequate fact-finding or scarcity of motivation, in order to enter substantially in technical economic assessment. Reference to the concept of technical reasonableness, in order to verify the reliance of administrative evaluation. And in very important cases of 2016 on energy tariff regulation, a judge has stressed the need to turn to the same technical rules by the regulators and use this expression. It is important for the court to evaluate the regulatory decision not through the common people eyes, but through the expert eyes, namely reusing the same technical rules used by the authority. In this perspective, has been also stressed, for example, in electronic communication, the duty to verify the correctness of economic model applied by the authority on electronic communication. Very recently, there has been a judicial intensification also in another sector that were traditionally characterized by a stronger deference, the pharmaceutical sector. In a very recent case, is December 2020, the Council of State has contested the reliance of the assessment carried out by the Italian authority on pharmaceutical sector on the efficacy of hydroxychloroquine to defeat COVID. According to the administrative judge, the courts must be able to verify that administration has applied correctly to the specific case in accordance with the principle of the chosen scientific method, the rules of specialistic knowledge applicable in the field of administrative activity. It is necessary to carry out a direct verification of the reliability of technical operation in terms of consistency and correctness. And this model of review aimed at verifying the possible violation of the principle of technical reasonableness must use the same technical knowledge belonging to the specialized science applied by the independent administration. But beyond this declaration, in the concrete case, the judge has tried, first of all, to understand internally the main tendencies, including also the methodological ones that were characterizing, especially a few months ago, the scientific debate at international level on hydroxychloroquine efficacy to defeat COVID. And on the basis of this scientific assessment, he challenged the scientific relevance of the studies taken as a reference by the agencies, since they were not consistent with the objective, with the specific objective of regulatory intervention. In particular, the regulatory intervention of the authority aimed to verify the effectiveness and risk of the drug on patients with COVID who were not in serious condition. But the agencies, for this reason, was wrong to base its decision to prohibit the use of hydroxychloroquine on studies that exclude its efficacy for patients in severe condition, since it was a clear point. Agencies should have limited, on the contrary, the assessment on the effects of drug at an early stage of disease development for not serious patients who do not need hospitalization. So for this very reason, according to the court, the assessment has not always been based on an irreproachable methodological approach that would allow to preserve both the requirements of internal and external validity and the analysis conducted with respect to the purpose of the research. Has been also contested a lack of reliability since the agencies has used inadequate endpoints in this assessment. Of course, the judge is aware of the structural difficulty during a pandemic crisis of carrying out randomized and controlled studies on patients at home, but mainly for this reason, according to the judge, in a situation of scientific uncertainty, it is necessary to encourage a responsible testing of new drugs, at least until a reliable contrary evidence of the ineffectiveness of the substance. From this point of view, the authorization of temporary use responded to the public interest in encouraging the testing of therapeutic alternatives to hospitalization, which is fundamental considering the absence of viable alternative for the treatment of COVID for patients at home, and also the strong scarcity of beds in hospital intensive care. It was autumn 2020 during the second wave. So through this case, it is a very important decision also because it occurred during the interim stage of the administrative process. As a result of this interim measure by the Council of State, it is almost 40 pages of very technical decision. The Council of State allow local doctors to administer hydroxychloroquine on the basis on informed consent by the patient, even if the authority forbid the use of this drug before the litigation. Even if is not provided the reimbursement of the cost from the National Health Services, for which it is necessary to be sure of the therapeutic efficacy of the drug. What we may say about some tendencies in Italian case law, of course, the increasing intrusiveness and activism of courts, of Italian courts and European courts in judicial review represent an important tool to ensure not only the lawfulness of administrative decision, but also an effective judicial protection of citizen rights. At the same time, there are some critical aspects, in my opinion, that emerge from this recent tense. First of all, judicial activism characterizes only some of the most important cases in the field of independent authorities and not all disputes concerning complex technical assessment. For example, we still have deference in environmental field. In this perspective, it is related to a lack of clarity about the criteria that may substantially justify judicial activism. It is related to a pure tendencies of civil law country administrative courts to explain the substantial reason for deference or outlook beyond the formal reference to abstract concept and theoretical category, discretion, technical discretion, abuse of power. So there is a lack of clarity on the substantial rules. For example, how significant is the peculiar nature of independent authorities in order to shape the intensity? How is important the relevance of the matter for the European integration process? How is important the economic relevance of litigation? These are questions without explicit answer. It should be necessary probably to shape the intensity of judicial review, also declaring the substantial reason to defer in order to help the courts to rationalize the scrutiny. Even the reference to the more or less scientific nature of the assessment, which is the main topic of this lecture, is not very easy to define, having regard also to the great extension of technical rule in every field of action of the administration. Probably scientific nature and technical nature of the assessment is something that is present in a very lot of field. On the contrary, it's very difficult to underline when we are before a purely technical dispute. In my opinion, it's impossible to exclude also subjective evaluation or the exercise of discretion in several fields characterized by the abstract application of scientific rules and criteria. The administrative decision to commence an antitrust procedure, to apply a certain criterion to regulate the cost of access to the electricity grid, or to prohibit the use of a certain drug, is not a merely technical decision. This is a very theoretical point. It is a problematic aspect for the intensity of judicial review. In the case of hydroxychloroquine, court has considered also the achievement of certain public interest, for example, the need to reduce the pressure on the hospital during the pandemic crisis. So the incorrect or correct application of technical standards depends also the proportionality and the reasonableness with which have been achieved the purposes of regulatory intervention. And of course, this mostly happens when such technical rules are characterized by several margins of scientific uncertainty. This does not mean that technique is at the service of politics, as claimed by Carl Schmitt in the 30s in the categories of politician, but simply that it's natural to take not purely neutral decision, also in field characterized by strong presence of technical rules. The lack of clarity as to the basis and reason for a stricter judicial review, there is a very high risk of a case-by-case approach or contextualism approach, which may have harmful effect, both for the quality of regulatory process and final decision, weakening the scientific soundness of the decision, and is also considering a lacking inclination of the courts, also the Italian and the European courts, in concretely relying on specialized external consultant in order to be supported in the assessment. So we have an activism, but without the use of external technical consultant. Of course, these tendencies may undermine the importance of administrative procedure as the main and the most important place to set the scientific reliability of the decision. Another harmful effect is related also to the mutual trust between regulators and regulated. An intensive and unpredictable judicial scrutiny on complex assessment may represent an incentive to the judicial review. Is it confirmed by, for example, the high rate of claims against the Italian antitrust authority? Almost 80% of final antitrust authority decision concerning cartels and abuse of dominance have been contested by the private parties before administrative judge. And it may encourage, in my opinion, an over-representation of some interest through a possible abuse of the system, and particularly of those systems that are much more able to take an action, also for economic reason, the minoritan bias. And for this reason, it's important to preserve the centrality of administrative procedure as the place where it's possible to give representation to all to all interests, and also to all scientific methodological aspect of the scientific decision. Final point: how is possible to reach a better balance between administration and judge? Beyond the alternative, the rigid alternative between activism and deference, in my opinion, it is necessary to identify more solid criteria for streamline, rationalize judicial control on administrative activity. Of course, the strength of judicial review lies in its flexibility. But at the same time, it is necessary to limit uncertainty and instability in order to safeguard a rational balance among different powers. Rule of law imposes not only an intensification of judicial review, but also a deeper predictability of the scope and limit of judicial intervention. This is important to increase the accountability of the courts, which in chaotic system are more inclined to substitute the legal-based rationality with the politics-based one, as some US studies have demonstrated, Miles and Sasten. To this objective, it could be useful to place the problem of judicial review within a wider comparative institutional analysis. Also, beyond the type of matter and interest involved, it should be taken into account a broader set of institutional elements in order to individuate who is the better placed subject to take the final decision from a substantial point of view. And in order to analyze this point, it should be taken into account the feature of the first instance decision maker, the typology of procedure, if it is used an investigation and factual finding based on adversarial or inquisitorial system. It is provided a separation between investigative and decision-making body if there is a participation of independent experts. Also, it's important to consider the level and scope of participatory guarantees. Since broader procedural guarantees, the more restrained judicial review may be provided. As to the feature of the courts, in my opinion, it's necessary to go beyond the traditional dichotomy, ordinary common law courts or special court, which is not relevant aspect for the intensity of judicial review, but it's important to consider the level of specialization. For example, the presence of non-legal experts or subject matter specialization, as it happened in some competition appeal tribunals in Europe. But it's important to consider also the structural organization, powers entrusted by the law, but also third parties' prerogatives. All these institutional elements that are related to the feature of the administrative, of the first instance decision-making process and the feature of the courts should be considered in the definition of the appropriate standard of judicial review in order to ensure a fair balance between administrative procedure and trial, but also a rational distribution of competence and responsibilities between administration and judge. The aim to ensure justice in the administration cannot be delegated only to the judiciary moment, as often it happens for those countries that are characterized by a little confidence and trust in administration, such as Italy. Administrative justice means a wider and a richer sets of tools, not only judicial, but also political, legal, managerial, financial, and market-based, that may ensure the acceptability of the decision. As Jerry Machaut stressed in 1983 in his book on bureaucratic justice. So in this perspective, the concrete way in which the administrative activity is actually organized and shaped represent the first step to assess the proper scope and intensity of judicial review, as well as the first tool to safeguard a real justice in the administrative field. Thank you for your attention.
Thank you very much. Thank you for this interesting and stimulating presentation, Professor Moliterni. Personally, I'm truly impressed by the seminar. Now, please, all are welcome to share their questions, comments, and of course, contributions. Fehmi Levent Özkan is raising hand. Please, Fehmi, go on.
Hello. First of all, thank you for your presentation, Professor. I'm a graduate of Kadir University, and I'm currently doing my master's in Maastricht University on forensic criminology and law. So my question will involve a bit of a criminality or a criminological perspective, which will hopefully be a food for thought. So you have identified two approaches of administrative judicial review. First one being a more broad and laissez-faire approach, while the second one being a more restrictive approach. Could we make a causal link or some kind of a correlation between a country's levels of corruption and the way of review they choose to make? So could a more stricter approach prevent corruption, or would corruption lead countries to adopt more stricter approaches? Or could there be such an idea like that?
It's a very important question. One of the field of research in my university is also an anti-corruption strategy, and my Professor D'Alberti has directed Master of Anti-Corruption Strategy in the Italian legal system. In Italy, we have very important, now it has become a very important field also for public lawyer. We have an anti-corruption authority, so it is a very crucial point. I don't think that there is a strict relationship if we consider that, for example, a more differential approach characterize some system, of course, a US system, but also other common law system, also a system that belong to the Commonwealth, where there is a high level of rule of law, integrity in public sector. I think that the problem of corruption is much more related to the concrete way in which institutions are shaped and they function. So there is a strict connection, for example, between simplification of administrative sector, administrative field, and a low level of corruption. Of course, a judicial court is an important tool to ensure rule of law and so on, also to avoid corruptive practice. But I don't think that the intensity of judicial review is the most important instrument to defeat corruption. But is my opinion.
All right, thank you very much.
Thank you. Any other questions or comments? Actually, I have one that I received from the chat section from Atakan Uzun. He says that he asks, is there a different set of criterions for technical assessment of rulemaking acts and individual acts, or is it only possible for rulemaking acts?
Atakan is a very good question, because I missed this point, but as you listen, the most important cases in the EU experience and the Italian experience characterize the most important typical individual measure that are sanctioned in the antitrust law field. So in this case, and also the European Convention of Human Rights has asked for a full merit review for sanction in antitrust. So in that case, in the individual measure, the problem of intensity of judicial review sometimes is strictly related to the violation of individual rights or fundamental rights. So there is a strict connection between the technical relevance of the fields and the problem to defend also individual rights or fundamental rights. At the same time, for the regulatory measure, it is possible to find much more differences between systems, because the case that I mentioned about the US system of traditionally deference approach are related to regulatory process, are related to the interpretation of status, and in some fields, not in in every fields of European legal order, we are stressing, it is emerging an intensive review also in regulatory process, especially in risk-based regulation. There is a difference between the process that are conducted by Commission and agencies, but we are analyzing, we are highlighting this this stricter approach also for regulatory measure. But of course, the most important fields where it is possible to find an intensive approach, and it is the field where in Italy, for example, in the case has been stressed the importance for the courts, not to replace, but to analyze the most reliability of assessment is the antitrust law cases that are typical individual measures, and according to European Convention on Human Rights are also measures that are characterized by penal relevance, so substantially penal relevance. So on this perspective, there is quite a difference between individual and generally measure and procedure in the intensification of judicial review.
Thank you very much. And actually, Atakan has another question too. And he says that, is there any room for judge to rule against report of technical experts, or is there a debate in Italy about technical experts' influence over the judgment?
No, in Italy there is the possibility for judge to seek and to ask for technical advices. The very problem is that usually judge tend to be activists, tend to do a very strict review, but with their own knowledge, using knowledge that they may find in the common sense, or using logic without using consultants. So consultant now is allowed to enter in the trial, in administrative trial, but is not so frequent. It is something that emerged also in the EU context. So from a formal point of view, judge may seek the consultant of expert. But in practical terms, even if we are activists, when we use an hard look approach, they tend to not use and not to refer to this consultant. So this is a very problematic aspect, because there is the risk of substitution of the logic of the first instance, the administrative decision maker, with another logic that is the logic of the court, without any technical support. And this is a very risk in this stage of evolution of judicial review.
Okay, thank you very much. Any other comments or questions? You may raise hands and also write on the chat section. If not, actually, I have a question. So it's a general question, actually, but I've never been worked as a lawyer. But in general, one of the most common critiques of the lawyers is that the judges are consulting an expert, even the subject cannot be considered as a technical assessment. So it is commonly criticized, especially by the lawyers in Turkey. I wonder if there is such a common practice in Italy or not, or there is such a criticism.
Yes, of course, it is a point that it is stressed also in the Italian experience, because also in the dialogue between experts that are provided by the parties and experts that belong to the judge, there is difficult to reach a proper balance. And of course, this is a substantial argument, a substantial critical argument that sometimes emerge, and that sometimes it is at the basis of some differential approach, because it's not very clear which are the elements, which are the factors that may support more intrusiveness approach of the courts, and this beyond the problem of dualistic or monistic jurisdiction. In Italy, we have dualistic jurisdiction, administrative courts and ordinary courts, like in France, but nowadays is not a very crucial point, this one, but there is a problem of reliability on technical assessment, also provided by the courts in general terms. And this is an argument that sometimes emerge in a substantial way, not in a formal way. So, yes.
Thank you, Alfredo. Professor Arat is raising hands. Please, Professor.
Thank you, Aslı. Dear friend, thank you very much for your presentation. It was really brain-opening for me, because I love the comparison with the US system. And my question is mostly related with this comparison, actually. But before my question, I hope you accept my apologies for forgetting to mention Professor Marco D'Alberti, that I know that you have this master apprenticeship relationship and you started your academic career with Professor D'Alberti, as the same case with me, with Professor Özay. So we pass our best regards to Professor D'Alberti. Hope to see him soon in maybe in your reunion in September this year. So my question is a bit general. I'm curious how you read the new positioning of administrative law, because and the way it is, its judicial review is done. Some scholars think that the EU administrative law is slowly shifting to US understanding of administrative law, but some assert that they are converging in one way or the other. So how do you read this picture? Because in Turkey, for example, this we follow this French system, the continental Europe. We started with that, but now we come up with the US. We are approaching to the US system as EU do. This is my understanding of this is my reading of the picture. I mean, for example, this independent regulatory agencies, it's purely US concept of administrative agencies. So in that sense, how do you read the picture in general, considering the concepts and institutions of administrative law, the converging or shifting one from the other? How would you read it?
Thank you, Nilay, also for mentioning Professor D'Alberti and Professor Özay, that, if I remember well, was in connection with Professor Giannini, that is the most important administrative law scholar in the last century. It was in Sapienza, and so I remember this connection from Sapienza and
that's correct. Professor Özay also was studied in Sapienza for a while. His LLB degree from there, and then he was working there for a while. And then they are very close friends with Giacinto Delle Canane as well. Yes. But I don't know, maybe you are not aware of that, but he passed away, unfortunately, last year. Yeah,
yes, okay. I know.
Yeah, from the academy.
That he studied in the Institute of Public Law in the Faculty of Law. That is the institute that where is my office. So it is the core of public lawyers in Sapienza. And
yeah,
I remember this point. So thank you very much. As to the convergence and divergence, of course, in the administrative law system, we, in the last 30 years, we have it's possible to stress a lot of convergences in the system. You mentioned independent authorities, but also procedural guarantees, the importance of administrative procedure. Nowadays, there is a huge debate in the European context to regulate a common discipline of administrative procedure. But of course, the importance of procedure is one of the most important pillars of a European system. It is a pillar that we find that we, especially for the general measure, especially for the regulatory process, is something that is related to the APA system. In Italy, for example, we have a law, the law that regulates the administrative procedure that expressly does not apply to regulatory process. So in this perspective, the European Union has been very important to put a connection between the US system and the member state system. As to the judicial review, probably the difference are still relevant, but are different that are not related to the technicalities of the system or to the structural system of the trial process. In my opinion, there are different that are much more related to the constitutional, the different constitutional dimension. We are facing in Europe some problem of from a constitutional perspective and institutional perspective that may justify a different role of the courts and European Court of Justice in leading this process of European integration. That is something that is completely different in a much more consolidated system such as the US one. So in this perspective, judicial review is a multi-phase instrument that serves, of course, to protect individual rights, to ensure the application of the law, but as always also an institutional relevance. And so the difference that remain in the two approaches to the technical assessment, but also to other approaches in judicial review, are mainly related also to the different institutional and constitutional legal order which still characterize the European system. Also for the position of the independent agencies that, of course, we have also in our countries, in European countries, we introduce independent agencies, but the peculiar relevance, the institutional position of independent authorities in the US system is something that is impossible to replicate in other systems. It is, in a strict sense, a fourth branch of power. In Italy, we try to say at the end of the day, the Constitutional Court 2 days ago say that at the end of the day is a normal administrative power. So in order to put these agencies under the umbrella of administration in a broader sense. So the institutional position of administration and the constitutional context where administration work, I think that is one of the most important points that contribute to seek some differences in a context of progressive convergences among administrative law systems. That is quite evident, as also the comparative law studies highlight. No, there are a lot of center of research of comparative administrative law nowadays, and it is very important also in order to allow and to facilitate these convergences in the system. So.
Thank you very much.
Thank you to you.
Thank you very much. So any other comments or questions, please? I guess we have no more questions. Now I would like to give the floor to Professor Başak Baysal, the Dean of Faculty of Law. Please, Professor.
Thank you, Aslı. Thank you, Professor Moliterni, for this wonderful presentation and for accepting our conference invitation. It was such an honor for us, it's for sure. And in the future, I know that we will continue to collaborate together. But my hope is to welcome you again, but definitely not in a Zoom meeting, but in Istanbul in a sunny day. like today. Springtime is the best, and maybe next year in the springtime we will meet again in Kadir Has University, like the last time as you came to Istanbul. And this is the last seminar, last comparative law seminar of this year. And for that, I would like to thank all the members of the faculty and the university who helped us in the organization of this seminar series. Special thanks goes to Professor Arat, Director of the Kadir Has University Liability Law Research and Practice Center. It's with her that we organized this series, seminar series. It was, I mean, it's my opinion, but probably you will all share this opinion. It was such a fruitful and comparative academic year for us, despite the pandemic. And as I said before, this is the last seminar of this year, of this academic year. We hope to see you all again in October. Until then, stay healthy and keep following us on social media or social media accounts. This is the, I mean, I think the usual way to closing an academic year now. And grazie mille, Professor, and arrivederci.
Thank you again for your invitation. I hope to come back in Istanbul physically. So thank you very much. It has been an honor for me to be here today. Thank you. Thank you, Nilay, and thank you, Ashley.
Thank you, Alfredo.
Thank you. Thank you very much. So dear professors, dear colleagues, and dear students, thank you for participating. We are now closing the session. We wish you a great summer season before meeting again for the seminars in fall. Bye.
Bye. Thank you.